All right. Hey, Steve.
Yeah.
Welcome.
Thank you.
I think it's our third time doing one of these,
It
talking
is.
AI and the law. Welcome back.
It is. It's great to be back.
Some big changes for you since
Actually,
the last time we did one
yes.
of these, right?
Yes.
Share a little bit about that.
Sure. Yeah. I'm pleased that as of like November 1st, I came out of my 300 lawyer law firm and formed Britt Law, which is primarily me for the moment. I had previously been counsel for cyber, data privacy, and technology for Parker Poe Adams and Bernstein, a wonderful firm of almost 300 lawyers based in Charlotte with offices Atlanta and DC. And they hired me 4.5 years ago to kind of build a data privacy practice. And I found that given with the explosion of AI, it's easier for me to do what I believe needs to be done, follow my passion for data privacy and now AI on my own, actually. Great relationships there, and I can use them for things that I don't do. And a reminder, I hold 3 certifications for data privacy and AI, and the CIPP, which is for Europe, or GDPR, the CIPM for privacy management. But now, as of 3 months ago, the AIGP, which is the Artificial Intelligence Governance Professional. Very proud of that. A lot of work went into it. And it really has changed, as we've talked about. My whole view about data issues, it's data privacy and it's AI, it's really data management. So thrilled to get in there. I really appreciate the chance to do these little webinars with you. And I'm fascinated by your technology insights on the questions I frame legally. And this is all moving so fast and so broadly that it takes a little bit of a village to figure out what compliance really means.
Yeah, and it really is moving fast, right? Yeah. Like we're going to get into just some of the most recent changes, but I mean, I think you're on the forefront of what really needs to just be figured out.
Right.
And everybody's trying to figure it out because now we're deploying all of these AI models into all sorts of things that we're doing, sometimes faster than we even understand what they're really doing.
Yeah.
And now the legal regimes are trying to catch up to figure out what to do.
Boy,
next,
they really are.
Right?
Yeah, the technology is moving so fast, and I think a lot of people not really focused on. I mean, the copyright issues and the open AI and scraping, the internet scraping, those all kind of were the first issues to hit on whether the developers of AI systems had the right to use the data that they trained with.
Right.
But that's quickly evolved into even bringing the technology behind the firewall, taking a license and then modifying it by the business. I think people are not up to speed with the compliance issues they're gonna inherit with that.
So let catch us up. Like, what is the current state of the legal regime for like, I'm using AI in my business, I want to stay compliant. What should I be thinking about?
Yeah, and I always go back to data privacy because again, these 2 regimes, GDPR went into effect in 2018, global, 27 member countries automatically in effect. And then here came the US, California jumped out first. So really, as of now, we have 22, as of through 2025, 22 state data privacy laws. And I'll just tick through them: in California, Virginia, Colorado, Connecticut, Utah, Washington, Nevada, Florida, Texas, Oregon, Montana, Iowa, Delaware, Nebraska, New Hampshire, and only New Jersey, Tennessee, Minnesota, Maryland, with Indiana and Kentucky going into effect in 26. So, and many of these laws are very similar, but they all have their nuances. So the data privacy side of the equation and the regulators, the most aggressive regulators so far, California, Colorado, Texas, Oregon, those are probably the most aggressive. That if you're in those states, better be careful. But
what about if you're not? So, we're sitting here in South Carolina. From a data privacy perspective, like my experience is we usually care the most about California and Europe because they're the most stringent.
If you're in
and if I'm doing business at all with anybody in there, then those laws affect me on a privacy front. Is AI the same?
Well, AI, so on the AI side, of course, we have the EU AI Act, which is now in effect as of August 24. Like GDPR had a 2-year transition period, The EU AI Act is a 2-year transition, and parts of it 3 years. It hits generative AI models a year from now.
Okay.
It's a but the key about the EU Act is it applies to any AI system developed or deployed into Europe from anywhere in the world. So if you're building an AI tool, your use case is going to be availability in Europe, to even used by EU residents, you've triggered the EU Act, and we have this whole compliance regime that we'll chat about. So the EU Act is already bifurcating the market on the development side, that you've got to have it on your scope based on your use case.
Right. And so, as somebody who is building an AI tool and who is selling an AI tool to other companies to deploy into them, basically if I or any of my customers are doing something in Europe, we need to care about the Europe laws. If I or any of my customers are doing business in California, we need to care about the California
laws.
And
it's the state of residence of your users or consumers. Right. And the one distinction I would make, the AI laws do not replace or change anything about the data privacy laws. So if you're doing business in Europe and triggering the EU AI Act, as part of that tool, if you're handling personal data, is the term that GDPR uses. If you're dealing with personal data, that's a GDPR issue. You have to comply with both regimes. Right. One does not get you out of jail on the other. And it makes the analysis, therefore, again, back to why I feel there's a great opportunity, is we're at the stage, we're still early enough, the laws and regs are coming, you can see where they're going. But this is kind of a consulting kind of practice. Like, I found that being in a larger law firm with high hourly rates, it's a little bit like the difference from data breach versus data privacy. Mm-hmm. So data breach is a big firm kind of practice because your hair's on fire, you got a ransomware, you got clients and customers, liability, reputation, and you have to go out to a firm with expertise and pay large hourly rates.
Yeah.
Data privacy, you got to build it inside the enterprise. You have to have a data privacy program that takes into account how your business operates, how your individual departments handle data and different data. So it's really more consultative than it is kind of outsourced legal, which I have found. The other thing now, being on my own, I can charge different. I can be more entrepreneurial and help clients at the planning stage at a much lower hourly rate than actually building policies, procedures, and programs. So I'm confident that my vision of being able to help clients plan, predict, understand, even if they don't begin implementing immediately, because the laws and regs are changing so quickly, that compliance is kind of in quotation marks. It's just not clear. And the big question we have now, 3 states, California is really getting aggressive on the regulatory standpoint, and they're about to drop a new regulation with risk assessments and automated decision-making technologies assessments. But it's all done under the California Consumer Privacy Act, so it's all dealing still at the end of the day with personal information. Colorado has an AI Act and a Privacy Act, but you trigger Colorado Act if you're machine processing of data. It doesn't have to be personal information. So again, it's the big question here is when and how does Congress act? Social media platforms are becoming a big driver. Protecting children is becoming a big driver. So the question is, when the Congress moves, do they move on data privacy too? Or do they try just to deal with generative AI, which has been obviously the big noise factor?
Right. So that's a lot to keep on top of. And part of the reason I keep inviting you back is so I don't have to go read all of this and you can summarize some of it for me. And I think our audience appreciates that too. Yeah. So you've been working on kind of a what we call it, a framework for trustworthy AI.
Well, yes, I have. And the federal government, President Biden in October of 23 dropped an executive order, 110 pages, that affects every federal agency, imposing the duty of responsible AI governance to any agency which intends to acquire or use commercial AI. Yeah. So if you're developing an AI tool and your customer set is in the federal government, you're going to have to meet these
Right.
these requirements for responsible governance. But these responsible governance, this is AI risk management framework, NIST. The one thing about AI is every jurisdiction is picking up these same kinds of compliance requirements.
Right. And I think the good thing about it, like what I've looked into here, it's all fairly sensible stuff, right? They're not, there might be some that's imposing really complex things, but for the most part, it's like, do you know what your AI is doing?
Yeah.
Right. And how are you using it for the right things and all of that? And so can you talk through some of that framework? I think you've got about 8 bullets here.
Yeah, and I look to you because you're the technologist and you understand, and you're taking such a open-minded, experienced vision about it. So you're not trying to end run it. You're trying to make sure you understand and you can apply it, and that's fantastic. And clearly, whether it's the state or the EU, the areas that trigger what the EU calls high-risk AI systems are systems which are making decisions and affecting, they're like 8 broad educational opportunities or education, employment, banking or financial services, government benefits, right, or access to them or the terms that you get them, healthcare, housing, democracy, voting rights. So if you're in any of these broad categories of really our economy, and you're building technology which is making decisions that affect someone's either access or the cost or terms of those, then you're in the high risk area. Colorado calls it IAI, which makes a consequential decision. But what they're really saying is if your tool is making decisions about consumers affecting any of these broad categories. Right. So, one of the first distinctions, therefore, there are exceptions in all of these acts for internal use. You're trying to make your business more efficient. You're making decisions about your own business operations. You can begin to analyze that you're really not in the danger zone as long as you understand how the models were built, the data that they were built on, and you're going through a continuous compliance regime of testing, validating, and always ensuring that the system's doing what you think it is or what it was designed to do initially, which takes you to your governance points.
Right. So there's some things where lawyers might not come after me because of the use case.
Right.
But I still have a responsibility to use AI well.
Yeah.
Even in internal use cases. So let's talk about the framework. I'm looking at my notes here, what you shared. So, trustworthy AI standards. We've got valid. This should be valid, reliable, safe, secure, resilient, accountable, transparent, explainable / interpretable, privacy enhanced, human centric. I guess that's 11 now. Fair and harmful bias managed. So some of these are, let's say, easy to sort of think about and understand, like safe and secure and resilient. That's how we need to build software systems. That, like, thinking about things I've built in the past, right? We don't have to probably go too much into that.
Right.
Like, you should be using proper encryption. You should be, saving your data in more than one place, right? So it's resilient and you don't lose everything. Reliable. So I'm going to say reliable, safe, secure, resilient. There's probably not too much new from an AI perspective if you've been building software for a while. Is that a fair statement?
I think that's right. And however, again, from the regulatory standpoint, you're going to have to validate and report. You're going to in the EU Act, you must establish that you're in compliance with the EU Act before you deploy it.
Okay.
So you're going to have to think about from a record keeping and how do I prove those points and make your case a little bit for the regulators that you comply with the EU Act before deployment.
Yeah. And
along the way, you have to register your system in an EU database, and then any security incidents or failures or upgrades or diminution in these standards have to be reported. So the one thing for sure, the record keeping and validation of compliance is something that needs to be on your scope from day one.
Mm-hmm.
The valid point is really that the model was built on data that you had the right to use for that purpose.
Right.
It's not just, I got data that I had the right, I collected a bunch of data even on my own users, and I had privacy notices that complied. Did you disclose that it might be used in an AI model? Unlikely. So
Right.
now you may have to go back and kind of clean up your rights to the data for that purpose.
So I've been getting a lot of emails recently saying, hey, we've updated our terms of service to, help you have a better experience on our site. And you dig into it a little bit and it says, oh yeah, this is because we're going to use this to train models now. So some of that is companies are catching up to this and saying, okay, we know this data is valuable. We know we want to build models off of it. Now I need to let people know. Yeah,
good point. And we had this discussion last time, and I went into like the 6th largest OpenAI and Copilot and Anthropic, and looked at their terms of use, and generally on the question of, do you own the outputs? And on those standard terms of use in most of the large public platforms for AI, they say in their terms of use that you, the user, the customer, the licensee, will have all right to the outputs.
Mm-hmm.
But then as you drill down deeper into their own terms of use, they're retaining license rights to use it to improve their own models and validate their own models. And you start to get a sense of conflict between, well, what's it mean if I own all my outputs, but you're retaining the right to use the outputs to make changes and improvements and enhancements, including for other customers. So it's a bit of a sticky wicket on that. The other thing, the FTC has recently said, on your point about changing terms of use, that changing terms of use to affect the data rights may be an unfair and deceptive practice. So the FTC is already kind of making notice of, be careful about changing terms of use on AI systems on your users. You're probably going to have to go back and get a separate consent. And all consent from GDPR on is valid, knowledgeable, disclosed, transparent. You have to explain exactly what is the impact of what you're doing.
So we might start seeing like the cookie notice that's on every website saying, do you accept the use of this?
Well, people are trying to figure out, the U.S. has never adopted a cookie notice. The GDPR, of course, which actually goes back to the, not GDPR from 1995, but the, I've gone blank, their e-commerce reg, but that required cookie notices. That's really, they sprung out of Europe. The U.S. really has never required cookie notices.
Yeah, although I'd say most sites have them at this point.
Well, and the Attorney General of California has made very clear regulatorily that using a cookie notice to try to get consent for data privacy is invalid.
Sure, that makes sense.
Yeah, so it's a cookie notice is not intended for that purpose, and that's not valid consent.
Okay.
Yeah, so again, the regulations are very prescriptive. California's over the top, but Colorado, since they have both a Privacy Act and an AI Act, I think is the leading authority, although as we will see, California is passing by regulation all these requirements for cyber and risk assessments, ADMT, the automated decision-making technology assessments. So it's and so all of those assessments require a weighing of the benefits, like of the 22 state data privacy laws, all but 2 require, sometimes they say, annual data protection assessment for data privacy. And what you're supposed to do is weigh and balance the benefits of that data processing activity. Any data processing, this is not AI now, this is just data processing activity. What's the benefits to the company of doing it? What's the potential risk, adverse risk on the privacy rights of your users? And then what steps have you taken to mitigate it, which is encryption or de-identification or segmentation. So I've drafted draft reports. There aren't any real models out there, and we don't have to boil the ocean. We just have to pick up the 5 or 10 main processing activities you're doing with data, how you're using it, and then just describe the benefit to you and how you're protecting the rights of and here comes AI to have the same set of issues. How do you prove that you're honoring the rights of the users?
So you're going back to this framework, and we talked about valid, right? That's really about, do I have the rights to use the data?
Right.
I think you're getting into transparent, which is the next one down here of, are we telling people how we're using AI?
And how do the algorithms work, and how are they likely? And again, in your compliance regime, you should be thinking of how you intend for it to be used and take into account foreseeable misuses.
Yeah.
So again, I'm envisioning that as we build reports, whether it's on the AI side or the data privacy or the merge side, which I think is where we're headed, it's data management compliance, that you've thought through and really knowing how your tool is built and how you intend to use it, take into account these potential risk factors and how you're addressing them.
Yeah. And I think, that's probably the hardest technical question in all of this is like, can I actually explain my system, and can I explain to somebody else how it's being used? And, I think you had shared this article with me on, people moving to small language models inside of businesses. Comes back to, what you were saying about, well, what is OpenAI, Anthropic, what is all their policies? And maybe, a lot of, especially in more compliance required industries, they're thinking a lot about this and like, we're just not going to use that. We don't trust it. But that means you can still bring in your own models, and then you get a little bit more control over it.
So here's my question to myself and for my clients. So just to make clear what the standards are, the EU AI Act talks about providers and deployers. Colorado is developers and deployers. So the providers, if you're licensing OpenAI enterprise version and pulling it in behind your firewall, OpenAI is supposed to give you the compliance standards for the tool as you've licensed it. And a company, they bring their engineers in and they develop and integrate it into their business operations. Then their downstream licensees, users, or consumers, if it's got a consumer-facing element, you're going to have to pick up the modifications and the enhancements, what kind of data you use to integrate it, and that's going to be a disclosure requirement going downstream. So what I think is a lot of people are focused on either the copyright risk or the effectiveness of the parameters in the model, but not thinking about their inheriting when they decide to do it themselves, rightfully so, integrated into their business. They have to keep an eye on the compliance requirements to prove that it was developed in a trustworthy, responsible way.
Yeah, and I think that it's complicated when you're using somebody else's model to answer parts of it. But the other thing I'll say from a technology perspective is, if we think about an AI system, like I'll put it another way, a system that uses AI somewhere within it. That's not necessarily, hey, here's a model. And like, we use a lot of AI in Querri, but it's not a, we don't just pile a bunch of data in and AI gives us an answer and then we go do stuff with that, right? That's would not be very transparent, and we couldn't explain to anybody what's happening anywhere, because it's like, it's a trillion parameter model, and it's very difficult to explain exactly what's happening in there. So some of it, I think, is, if I think about like a security review that I might go through on how the software is built, then we think about like, okay, what are all the different components and how are they being used and where are they being used and why am I using each one of these? And you might be using an AI model in a very small piece of the software. You might be using it in a bunch of different places, but like kind of diagramming that out and being able to explain to people, when and where and how are you using it, even if the model itself might be difficult to explain exactly how it's coming to the answer. I think you might be able to have your system be transparent enough and explainable enough that you could probably pass some of these. And we'll have to see, because a large language model is very difficult to say exactly why did it say this word instead of this word, right? Because it's a massive, complex model. But saying, hey, yes, we're using models in this overall system, but it's writing messages here. It's doing some routing between a few different systems here. And this is where we have some oversight on it is probably the more interesting thing. Now, coming back to the small language models, these are generally something that could run on a single GPU is how people think about like what's a small language model. So much easier to deploy behind a firewall on premise, lower cost to run in your own virtual private network or whatever. So you take one of those, and you're usually, to make those work anywhere near the level of the bigger ones, you might be taking an open source model, but then fine tuning it.
Right.
So now you are a developer at that point, right? So you have to think about validity and accountability. Well, you always have to think about accountability, but you have to think about validity of the data that you're fine tuning on.
Sure. Yeah.
And how did you get that?
And I love your point, because really practically, I mean, I'm a deep technology lawyer. And the regulators are full of lawyers. This is really data engineering, data science. Your technology experience and finding a way, helping the client for your own product, explain and put. I don't think there's any perfection here. I think there's a good faith effort. I believe, and I've been a former federal regulator for several years, that their regs are so prescriptive of what they're trying to. I don't think they can hold companies that make a reasonable effort, whether they agree or disagree with that finding or analysis. I think you're going to be fine. I think doing something is so much better than doing nothing.
Right.
It doesn't really have to be perfect, and it certainly doesn't have to be even complete, as long as you've tried to work through these standards and bring a reasonable interpretation of them. I think that's where we are. It's a little bit like the debate always, do Americans care about, do they really care about privacy? And of course, the younger generation, so it's all out there anyway. So it's, I think it troubles me that they're getting so prescriptive and granular with what constitutes compliance with the California Consumer Privacy Act. And you can't just talk about personal information. You have to use our 12 statutory categories.
Right.
Oh, please. And no one else. Every state says that in your privacy notice, you must disclose the categories of personal information you've collected. Only California gives you categories. So everyone uses California's categories. So it's gotten too far. But and then the big issue here is where's Congress going to be, and when are they going to be here? Because generative AI, those are all headed for disclosure. Now they're working on watermarking for content change. There's a bunch of technology solutions hoped for in the content manipulation side.
Mm-hmm. Interesting. Let's wrap these up real quick. So valid, reliable, safe, secure, resilient, accountable, transparent. I think we covered these off. Oh, and explainable, interpretable. That's the hard one. We talked a little bit last time around ML ops and some of the technology things that you can do here. So I think that's important. Privacy enhanced. What does that mean? Does that just mean focused on GDPR and data privacy?
And just that it's taking into account the potential adverse impacts on privacy rights. It really is just whether that's de-identification. The one standard that's in every statute that the regulators have not is data minimization. So in your collection, in your data privacy practices, you're supposed to minimize what you're collecting. You're not supposed to collect any more than you actually need and use.
Right.
So everyone talks about, the blogs talk about data minimization and how it's such a key standard, yet nobody's figured out how to really invade a business and make independent decisions about whether you really needed to collect that data. But it's out there.
Yeah. I'll give an example, see if this is right from past things that I've worked on. So from doing personalization, web personalization, I need to capture information about users of my system, right? It's every e-commerce site does this. Most sites do this. So I need to know what products you're purchasing, but when I'm building a model to predict who's going to use what, I don't need to know that it's Steve Britt at, such and
Right.
such an address at, with this,
Right.
your email address doesn't play any account here. Maybe you're the general, even like exact location shouldn't matter, but maybe the region that you're in matters, maybe some buying trends. But if I can de-anonymize that and still feed it into the model, you can do it in a way that doesn't pass the threshold of personally identifiable information, PII, right? If you anonymize it far enough, now you're able to build these systems that are useful. Like, I like it when Amazon recommends a product to me that I would like to buy, but I don't want that sort of filtering out that everybody then suddenly knows what products I'm buying, right? So that's especially in generative AI, where it might spit some stuff out later on, that's the challenge of
the data
right?
privacy side is all focused on your use of sensitive data, profiling data, and targeted advertising or transferring the data to a third party, which is the Google Analytics, the data analytics side of the equation into advertising models. So it's the whole Google cookies, pixel, using it, not using, what's the IDFA, what's the new tool that's going to kind of keep the advertising side of the revenue model for Google versus the risk to the privacy rights. And some of that, I think these things are going to be decided at the enforcement and regulatory investigations. If you've got a legitimate reason to be collecting these types of data, then it's going to come into, well, when do you delete it? Well, and certainly if you transfer the device data and shopping preference and history to third parties, that's what we're seeing with the tracking technologies debate, which is metapixels and people who are buying software development kits for their website and don't realize that it's inherently sending data back to Google and Meta. And there's a bunch of, and so here comes the litigators under California Invasion of Privacy Act. They're using existing privacy laws that have an ability to sue on them. Most of the data privacy laws, you can't sue on the law, but they're finding other avenues to sue you on about how your website is collecting data, and transferring it to Meta and Google, without your knowledge. Many times you don't know the software development code. You don't know if those pixels are firing and when they fire. And then the New York Attorney General ran a big investigation on e-commerce sites and found not only were the descriptions of what their site was doing was a misrepresentation, it didn't do what they said it was doing because the pixels were firing and the user, the website owner, didn't even know they were. So it's a jungle out there.
I've worked on some big websites, and I'll tell you, there's you'll have 70 different pixels on some of those going to all the different advertisers and marketing tools and platforms. So So
let's talk about, and we've talked a little bit about, from my vantage point, the assessment stage now. So we have even many of these statutes, in 25, we pick up another 8 data privacy statutes in effect. Even the Colorado AI Act is a February 26th effective date. The EU AI Act, and when the governor signed the Colorado Act, there were rumors that he was going to veto it because it was so broad. It really is a sister of the EU AI Act, just like the California Consumer Privacy Act was a sister to the GDPR. There were rumors the Colorado governor was going to veto that act, and he chose instead to kick the effective date into 26, A, to give the legislature more time to understand, does it need amendments, and B, to give the companies more time to react. So it's really, this is kind of a critical time as the data privacy laws were running, rolling out, and now we've got 22. It's a time for companies to begin to plan and prepare. You don't have to do all this today. You got to figure out the data configuration challenges. Where is this data being held and stored and used and transferred? This is time to do that. And you can do that in a consulting kind of relationship that educates the company on what they're triggering. And you on the technology side can help validate where the technology issues are, what they're trying to do, what the due diligence is on the data. So I think there are good opportunities now to make the best use of this time. I don't think it has to be that expensive at this stage. Just to review, understand, build a privacy committee or build an AI governance committee that's represented across all stakeholders. People talk about, well, how do you prove it's unbiased? And I said, well, one thing about artificial intelligence, if a human being's involved in doing anything about it, it's presumed to be biased.
Yeah.
You don't have to prove that it's complete value neutral. What you have to prove is that you've understood and investigated the potential biases based on who was involved for what purpose, and build a committee of stakeholders to make these judgments, analyze the risk, and don't just leave it to the technologists.
Right. And there are practical ways of removing biases. And I think it comes back to understanding what the AI system is, right? Like, where are we using some AI to make decisions? Where are we making humans where are we having humans make decisions? Like, from the overall, how are we approving this mortgage, right? Because you don't want to have one human be the final decider, right? Like, in a lot of ways, the machine might be able to be less biased.
Well, and there you go back into what data did you pull from, and how well did that data represent in an unbiased fashion stakeholders? You pulled from lower income or higher income or racially discriminate databases. So that valid was the data that was used. The training data should be kept separate from the test data. And so I come back to you on the data side and say, you've got to help do an analysis of why is it, and then as it's in operation, you got to be able to go back, and this again, your area, how do you go back and test those models against is it still doing what you think it's doing?
Right. Well, and the simplest way to think about this is, any machine learning model that you're building, you're going to have a training data set and you're going to have a testing data set.
Okay.
And there's good mechanisms for being able to, you build the model and then you measure it against this test data set. So a lot of it is going to be, how well have you curated and thought about that test data set? And if you're approving home mortgages, and you should be specifically concerned about different biases, well, it's going to take some humans spending a bunch of time to say, okay, let's go through these and see which ones should be approved and which shouldn't on merit. And then when we feed in our data, let's see that it doesn't introduce some bias. And some of it's just like, all computer systems are just inputs and outputs with some sort of gearbox in the middle. So a lot of it goes into what are you feeding in, and of course what's in the gearbox. But if you try to avoid pushing in things that could be used for bias, it's like when you do a double-blind study in research, right? It's like, well, we're not going to tell the person which thing they have. The more we can just say, well, you don't really need that piece of information that might trigger some bias. That's not relevant. Let's look at income history. That is relevant for if you can pay back your mortgage. Let's look at dings on your credit history in the past. That's probably relevant. But looking at, who you are, what you believe about something is not relevant. So I think a lot of it is just, do we understand what's being done here? And you can't just sort of non-discriminately throw a whole bunch of data at the system and expect it to come back unbiased. You would expect it to come back with some biases just based on other people's past decisions. And I think you have to go even further. Like, this would be the thing, is you can't even, in this case, just build a model based on what have you done in the past? Because as you said, humans can be biased as well. So then we can build a system that is just mimicking the human biases that are already there, but now we're codifying it in some neural network. And that's not that helpful.
Well, the human-centric, and California has been very clear in the new regulations coming out, and the FTC's picked it up, there has to be an ability for human intervention. So if it's making an automated decision about access to health benefits or employment, then there has to be a way, and California is very clear in its regulation, the consumer needs to know that a machine was involved in making the decision, and has to be able to request, the California regulation calls it access to the ADMT output, the automated decision-making technology, and has to have the right to request that another decision be made with human intervention. Well, that that has significant kind of development and production impact.
Well, it's like when all the privacy laws hit and you could suddenly request your 30-page,
right.
I'm sure you've done
privacy
these, right?
Exactly,
From what are all the things that they know about you or think about you.
Right.
That's a very telling experience.
Yeah.
You can do that in a bunch of places. And I was like, and it's a big, long printout of all the things that you might be interested in purchasing.
Yeah.
And, some of the more recent laws have made it a little bit harder for them to get some of that stuff.
For sure.
But that's an interesting one. So I think we've actually covered them all off. Let me summarize real quick. And then I want to talk about this, having this governance committee. Yeah. So we've talked about valid. It needs to be valid. You need to know where it came from. It needs to be reliable, safe, secure, resilient. It needs to be accountable. We didn't exactly say this. Organizations are responsible for the consequences of their AI systems. This is related to human centric, right? Like I think about this one, like if I have a Tesla with a self-driving mode, and if got it in self-driving mode,
right,
and I crash into somebody, I'm responsible, not Elon Musk.
Yeah, good example.
Right.
Well, and you may have a claim against Elon Musk, but it's and I love the term, instead of accountable, traceability, to prove who the developer, the deployer, who is responsible for that.
Right.
And
part of the way we get to that is by having this human-centric piece that you were just saying. And that's part of how we get to this fair, harmful bias managed. So we talked about transparent. We need to tell people how we're using it, explainable and interpretable. We need to understand what these systems are doing.
Right.
That starts with explainable to ourselves. Right. Not using a model that is just not explainable in the first place.
Yeah.
But then having the ability to communicate it. And we talked about privacy enhanced. So that's just to put a bow on that. That's the trustworthy AI standards.
Yeah, those are the criterion for responsible AI development, trustworthy, responsible AI development.
Yeah.
Which is, and let me say something about liability. So I mentioned a minute ago that the data privacy statutes say that there's no private cause of action for violating the statute. So if you don't provide appropriate disclosure, privacy notice, someone says, please, I want you to delete my data, and you say, I don't have to for these reasons, which are legitimate under the statute, they can't sue you for violating the data privacy law. In the AI arena, there's nothing that deals with liability. The standard negligence, lawsuits, product liability, those are not touched in these rules. The EU actually, with the EU AI Act, is working on a liability directive. And what you were saying, which is so relevant, the black box effect of AI systems is what the laws and regulations are really focused on, not knowing how it came up with something because the developer didn't figure it out before they released it. So the black box effect is how it's always described, of not being able to determine how that decision was made. That's really the underlying theme. And when you get to the ability to sue for the result from the use of the system, those laws are not changed. They're not providing any exemptions. It's standard tort law. And so again, the plaintiff's bar will be very active. In the EU Act, there's new liability directive is what they're calling it. What they're trying to deal with in the generative space is to go into evidentiary rules and say that they have the right to require the developer to validate why it didn't cause this result. And so it's going to be, and the fact that it's for European purposes, the fact that it's going to be a directive means every member state of EU has to adopt its own rules.
Yeah.
In the US, no one's talking, there's no discussion of any exemptions of liability for tort plaintiffs. And so it's another reason why you don't want to be the poster child developing technology and having it touch consumers. But again, we're so early. Where's the federal government going to come in?
Yeah.
The executive order is going to force all federal agencies that wants to acquire commercial AI technology to go through these compliance standards, and states are going to have to decide where liability lies.
Yeah. So I think we can assume anybody who's watching this right now is trying to get ahead of that. So what are our first steps?
Right.
And, let's get into talking about having a governance board. But what else should we be thinking about as first steps to say I'm using AI in my business, or I'm thinking about whether I can use AI in my business?
Right.
How can I do that responsibly? Like, what are my practical ways to try to start getting compliant with these frameworks?
Yeah, I just think I'm back to my favorite assessments. Privacy impact assessment is it's before GDPR came along, PIAs, and you'll see some PIA documents. And then here came GDPR with DPIA, Data Protection Impact Assessment. And then here come 22 state data privacy laws, say data protection assessment of analyzing the data privacy impacts. And now we've got AI, which is either a fundamental rights assessment or an EU compliance assessment. They're all requiring an analysis and a report. The state data privacy laws say it must be available to a regulator on request. I think where we're headed is that a state regulatory agency can go look at your website privacy notice and say, does that comply with our law or not? And if it doesn't, request the data protection assessment report available.
Right.
If you don't have one, then you clearly are not compliant. And I think that again, for my clients, I'm always counseling them. This gets started early, don't have to be perfect. I'll help outline a structure, but to your question, I think it's an initial assessment of what laws are they triggering, both sides. What systems do you want to deploy? How is it built? Let's put together a responsible AI committee.
Yeah.
It's got to be at the planning stages. These are all steps which I think you have to begin thinking about, fully understanding what laws you're triggering, for which reason, data privacy or AI. Build your responsible committee that will have authority. Make sure you've got an executive champion that, like yourself, that believes in it and will ensure that it's actually an analysis of risk. How's the tool going to be used? How are you going to build it? What license rights apply? All those issues should be done on the front end.
Yeah. So responsible AI committee, who needs to be in that?
All stakeholders, including all the elements of the enterprise which are involved in how the product's going to be deployed, used, and how the results are going to be used. But even if it's a tool that's going to touch the public and public consumers and stakeholders, you should have representatives of that group at the very early stage, and that helps you go through validating, so that if it's a mortgage finance tool, you need to have potential homeowners in your markets.
So you're saying a tool or a product, but organizations are thinking about rolling out AI in dozens of different places. Do you have an organization level AI governance board or committee?
Oh, for sure. It has to be enterprise-wide. What's interesting to me about the OMB, the federal government's telling the federal agencies that you must impose any contractor bringing you or anything you want to buy. And so it's going to have, if the federal government is a potential customer or target of yours, and those requirements are enterprise-wide. I mean, the AI governance committees enterprise-wide.
Okay.
And so I don't know, there'll be government contractors that may be doing one thing with the federal government. They'll have a commercial side. And again, I think there are great consulting opportunities to the agencies as well as to government contractors on helping them come into compliance. Again, I believe that if you've done this in advance and you say, here it is, here's my report on why this is compliant, you'll be legions ahead. And the main reason is you will have thought through, what are these standards? How do I meet them now or later? And that's, I think, going to be invaluable.
So a lot of it is, so you bring the board together, you're going to do some initial assessment of just where am I using AI?
Yeah. Why do I want to use it?
Right.
For what purpose? What problem am I solving?
Yeah.
And The other thing is you need to incorporate into your existing standards. If you're complying with GDPR, great. Don't bolt on a brand new systems. Roll it into your privacy protection program and just expand that. So the laws are not requiring you to kind of duplicate your efforts. They want you to integrate. And here comes the data privacy laws making you do some level of it. Anyway, the data privacy laws don't say you have to have a governance committee.
Yeah.
You just have to have taken into account all the potential risk and how you mitigate it. And so AI is going to greatly expand. That's why it's really data management. So your AI committee will end up being your data management committee.
Yeah. So I'm gonna get my board together. We're gonna list out all the different places that we're using AI or wanting to use AI, and then we're going to use some of these frameworks to basically say, is this high risk, medium risk, low risk in each place that we're thinking about using it, and then the higher risk ones, that's where we're really going to drill in.
Yeah, and then yes, and again, the analysis of what tool do you want to use? You're going to develop your own, and so if you're developing, you really are the developer if you're going to do it from scratch, which may be better for you for certain purposes, but to really analyze the use case and really, if you've acquired a third-party tool, you need to go back and validate how it was built.
Right, and this is just like privacy security audits, right? Like if I'm going to bring in an outside tool, I need to make sure they've checked all the right boxes and that they are doing it in a secure and private way. So we really are bolting on things that we have been doing, just with new ways of thinking about it.
The Barron's article you pointed out to me, which I thought was fascinating, because it says we've effectively exhausted the internet right now for valid data. We're running out of valid, high value data, which is interesting. And of course, if you're using first party data, if the company is using its own, well, that's great. That's valid as long as you're not leaking it or using it for other purposes.
Right, and that's I think every company starts to become an AI development company. Just like every company has become a software company, and the tools are getting better and better. It's becoming a lot easier to take a pile of data. The simplest way to fine tune, let's say we take one of these small language models that's been trained on a larger set of data. Well, if you want to hone it to give more specific answers based on what you have, you basically pull together a data set that says, for an input like this, I want an output like this. Right. That's your training data set. And it's becoming easier and easier if you have the GPU, and you don't even have to have GPUs. You license that. AWS reInvent is this week. They're launching all sorts of things that make that cheaper and easier. So, you go and click a button and, it takes that and it feeds this through, and now you have your fine-tuned model. Yeah. So the technical complexity of fine-tuning your own model becomes not that hard, but now you're starting to build the really interesting development in the AI space right now. What everybody's talking about is AI agents. Yes. Tell me about that. Yeah. So basically an agent, in a nutshell, we have the large language model. We, you type something in, ask it something, and it gives you some output, right? And it's really interesting as a chatbot. Think first versions of ChatGPT. Right. That's what you had. Well, if you have an agent, then what you're doing is you're using those capabilities, but behind the scenes, you're writing some code that gives that the ability to go and take some action. So that action could be going and asking another model a question. So you can start to do multi-agent things are interesting, where it's you have sort of think about a customer success scenario or customer support scenario where somebody asks a question. You might have a model that's really good at just being friendly, but also knows that it can go and ask 5 other models questions. So you might have another model that sits in front of a database search that's really good at going and finding an answer, bringing it back and summarizing it. And then that gets handed to the other agent, which then delivers on top of that. So where these small language models become really interesting is some of those things don't have to be that hard to do. So you can use this natural language ability of the model to go and stick it in front of some other capabilities, combine it with some other things, basically use it as sort of the reasoning engine, or you can really think about it as just the user experience. Rather than building big complex user interfaces, the experience is just chat. But then you have these different things that are able to go and reach out and do other things. And there's other components, like when you think about an agent, is like how well does it remember what you've done in the past?
Right.
How is it sort of managing the context of the conversation? Tool use is a big part of that. The other thing that agents kind of introduce, or we were doing it a little bit before the agent term started to come out, but
Right.
And this gets into actually a bunch of things here, is you can actually use an LLM to review the output of another LLM. So almost like having two people work together and say,
Right.
you came up with a blog draft and then I edited it, right? So we can use agents to do similar things, and it turns out the quality of the outputs can get a lot better when you sort of loop over it and check things. And then you add search, and you add this, this other type of tool use. Like, we do a lot of this in Querri in just doing kind of data science operations, right? So we're not just I mentioned that earlier, we don't just throw data into a model and get answers out. We summarize a bunch of things in a multi-step process, and then we use AI to basically come up with the formulas to be able to answer the questions, and then we pass that on to a series of other tools. So that's where I said earlier, like, we have this AI system that we're building that might be using 12 different models. And
your comments about multiple models simultaneously stuck in my mind about, let me process that. My other question for you is inferences. Like, talk to me about, so agents, and agents in the software world, in cybersecurity and other digital twins. I've kind of I wondered if the agents as used here was in the same context. Sounds like it is. It's just a different functionality. Talk to me about inferences.
Yeah, well, so inference is just, once you've built a model and you give it some new inputs, the inference is just the output from that. So it is inferring a response from whatever the input is. So when I go to ChatGPT and I type in, tell me a story about the Easter Bunny, and it gives me an answer, that is inferring what the right answer is.
Oh, because the inferences started showing up, and I think California Attorney General 2-3 years ago, the inferences derive from data with regard to a person's shopping history or research or search history. And they began talking about where our inferences, which are not really actual hard data, like, are they personal information? California early on said, no, they definitely are. So inferences on data that are derived from the data are protected as the data itself. So and now as we move to smaller models, and it seems like inferencing is such a sensitive new area. And, I've always often approached by people who are enhancing data. They've got access to these huge databases of 337 million Americans, and they can tell you anything about profile. And since the data privacy statutes are really putting special rules around your handling of sensitive data, do you have the right to handle sensitive data profiling, and restrictions on using data for profiling. So the area of taking data and then enhancing it with third-party data is a very sensitive area. California initially said in its data protection agreements that if you transfer data to a third party, the contractor can't enhance it with third-party data. Then they kind of retrenched from that. I think they got too much feedback from the advertising community. So I'm inferencing. I'm not sure how it fits into my legal regimes.
Yeah, well, I think it does, because it's basically, just literally think of it as the output of a model. Right. So you build the model, and then you get an inference from the model of what the answer is. So to your data enrichment question, you could enrich data by, you just have several data sources and you're joining them together. Or, the advertisers do a lot of this, like, they might be inferring that you are in the market for a new car.
Right.
because of some of your other behavior. They're not pulling that from another data set. They're just saying, hey, people like, and this is nothing new. Like this has nothing to do with generative AI. That's just like any machine learning model is doing some sort of statistical probabilistic guess. It's where it's inferring like, hey, I think you might be in the market for it. Just like a human would, right? We're using it in the same way. Like I might infer that you're on the market for a car because you walked onto a car lot. I might be wrong, but I'm probably right.
Yeah, there you go. There's a location-based data. So as the statutes rolling in location-based, and of course it's coming out of the Dodd's anti-abortion decision, where suddenly geofencing and using geolocation data to track whether someone's getting healthcare services resulted in that extremely broad. We now have, I think, probably 4 states that outlaw consumer health data, and outlaw it, but you have to. So that location-based data, which can be used to establish health services.
To infer like what somebody might want or be interested in.
Yeah, I mean, I've been approached by companies which are in the fundraising area. They want to take a client's database of donors or contributors and then enhance it and determine who's likely to give, or give more, or could give more than they're asking them for.
So there's another inference for you. It's like likely to donate or not, right? And so that's what we've had for a long time in different types of models that are doing, if it's regression or just some sort of classification model that's doing those. It's just what we have with language models and generative AI now is it's doing a lot of inference, and it's sort of inferring and inferring and inferring and inferring until it writes you a whole blog post, which is kind of a scale of inference that we haven't had in any sort of useful manner in the past, and now we do. So that's where, thinking about AI systems and agents and all of that actually in a lot of ways simplifies the problem, because we can break down the individual components and create this kind of, Sequoia Capital's got a good piece out right now, maybe a month back on cognitive architectures that we're building now, which is really about, like, we've got the reasoning layer from LLMs, but now we're basically building systems that model the thought process or the approach that a human would take. Kind of think of standard operating procedure, I'm going to do this and this and this and this and this and this and this. And we can use AI at different places in that to automate it, and then we can have the system spit it out to a human at another place and say, okay, yes, this looks good. And then the AI goes and finishes the other steps. And that allows us to have, it's maybe more individual inferences, but each question becomes smaller and easier to track and easier to decide, is that good? And easier to decide, could we insert a better model to make this smarter?
Last time, California Governor Newsom had just signed Assembly Bill 1008, and which went into the California legislature, passed, I think, 6 or 8 different state AI acts. The governor vetoed one, but that one that says that personal information under the California Consumer Privacy Act includes data held in an AI system model. If it were capable, if it were subject to being output or accessible. So and it struck me when you said, well, that actually makes sense to you, because you could definitely bleed and leak personal information out of models.
And I have seen that. There's a paper out there that showed that if you know the input sequences that went into it, you can get it to spit out the output. Like imagine a model trained on a bunch of people's information where it has sentences like Steve Britt lives at. And then, when you go in to the model and say Steve Britt lives at, then about 5% of the time it would spit out your actual address, not some made up address. Now that's not to say, and there's some nuance in here that would be interesting to get into, but a lot of those types of things, if you want to avoid an AI system from outputting that kind of stuff, adding additional layers in this kind of agentic system, you can have one that's doing nothing but saying, hey, is this outputting possibly personal identifiable information?
Right.
And if so, like obfuscate it or whatever. You could probably build a system that nearly 100% of the time, maybe 100% of the time, can avoid the output of personally identifiable information at the system level, not necessarily at the individual model level, but at the system level.
Right.
So and I've seen some very interesting things. Like there's an acquisition I was reading about. I forget the name of the company of a company that was doing legal reviews with AI.
Right.
I'm blanking on the name of it, but they were one of the earlier pioneers of this. Like, hey, if we just do a lot of review over this and add in some of the search stuff, we can make it pretty consistently accurate. They claimed 100%. I doubt that, but
Right.
Probably pretty close to 100%.
Well, this is your secure and resilient. I mean, this is really, is it secure? Is it capable of being manipulated, or the model being invaded and distorted? So I think this kind of goes to that's why I gain in our webinars, you from the technical side, I will think a lot about some of the things we've talked about today from the technology side, and how do I translate it from the legal and the regulatory compliance side, because you could chase these issues. I don't believe the regulators are going to be able to rightfully distinguish the 95% player from the 65% player, as long as they're making a good faith effort consistent with the policies and goals of the statute and regulation. But it will remain to be seen. And I think on the AI side, again, the fact that negligence laws, lawsuits, plaintiffs bar will be very much involved and looking for opportunities to sue companies is really the true threat vector.
Right.
Yeah.
Right. Well, Steve, this has been great. I think we went over a little bit, but people are still hanging around. Thank you for those who stuck around with us through all of this. But great conversation.
Yeah.
Look forward to the next time.
Thank you.
Thanks, Steve.
Okay.